summons. To the same mischief, Your Honor. Your position, Your Honor, was that you seek summons. Your position, Your Honor, was that no, you seek summons. Indicated to you. Was not indicated to you. That is to say, must be read in light of that mischief. That other than pursuing other ulterior motives that are politically actuated.
Apologies. You directed. Colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him to take the rest of his person. Let's not impute ill motive to anybody unless they are willing to test the law.
This is contained in the affidavit filed by the ODPP. That's not surprising, Your Honor, that the affidavit contains it has no tangible evidence that proves to the contrary. If I was to proceed in response to the substantive application,
to the law of God and will, avoid instances which may persuade me to request
the affidavit contains mere speculations. There is no averment in the affidavit.
after every sentence.
before you. There are varmints in the church. The affidavits have no nexus with the charges before you. Neither the prosecution, nor the defense, nor the court are privy to. Would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here. Are subordinate to the governor, the accused person, again, it is not contained anywhere in the affidavit. Has no protective value of whatsoever nature. And the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor. More of case. CH 046T it will not tell you the registered owner of KAE 7-8F. Is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests.
Mzee, ni aje? Ufreshi kabisa wewe.
Article 50 in isolation of Article 25.
Nini hiyo? Net nini hiyo net hapo kotini na kuangazia sana. Saizi hata sahi wacha nione. Sawa, wacha nikonfirm.
From Article 25. He tells you that the question if you look at the Black Laws Dictionary, Black Laws Dictionary, it will give you as to what is deemed to be compelling. No evidence. No evidence produced. No law produced. No law quoted. No case law. The integrity of the proceedings will not affect the so-called pending investigation open society. I invite Mr. So-called pending investigation open society. I invite Mr. Jero to guide us on who next. Thank you.
Another another learned friend.
This Willis.
We understand the implication. Right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say for wise Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue and Section 8 of the Magistrates Court Act gives you authority were search warrants. Not search warrant. Which they abused by literally and Nairobi bungling him into a police vehicle bail to deny bail. The High Court in must provide cogent, the term that is cogent evidence, and he keeps referring to some to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Transoya County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for lead escape. Jero was asked for clearance for lead escape to access his client. At what stage did the governor plan with the so-called agents to do the unimaginable things that the state is supporting? Your Honor, in Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor. 2 more minutes, I'll be done. If this court allows. I just have 2 case laws, and could I do that 1 case law?
If we can stick to directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5. I lost my eye to say you're finishing on the 6th minute.
Okay, just 1 more. In that case, you've recorded that the seriousness of the offense.
I repeat, 1 word is enough.
Lastly,
I don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
yes.
Sometimes it is counterproductive.
This last one, R versus Richard David Alden. R versus Richard David Alden. David Alden. The High Court at Nairobi, criminal case number 48 of 2016.
Second case. Just list that. I will look at that.
Very well. I think that was the last case, and that the person must demonstrate actual witness interference, not mere allegations. Witness interference. Employees of the county government are retained by county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simi was the accused person in the ACC. He can only say one word. He follow your guidance. If you allow. Mr. Simi. Your Honor, take 2 minutes. And I'm addressing
Proceed, Mr. Simi.
Thank you, Your Honor. Your Honor, number one, I just want to write on what Mr. Chester has said. The accused person did not have capacity to direct. Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. I believe you have 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, the averments in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accuse persons Itale Milimani residents. That is repeated at paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. One is Rongai residence in Nairobi. 2 is a residence in a place called Kipomet.
Come again.
First is
No,
a,
the second.
second is a place called Kipomet. Kipomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly, to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that have been annexed to the affidavit is illegally obtained. And we are not very cut that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to SOPEC.
I-
You read it reason.
I yield.
Honest to records.
Thank you.
No, I'll try 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop there.
Yeah.
The first point, Your Honor, is just to raise a point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Honor, Section 106, Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is accused. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Slow. Let me remind you. The applications contained in the
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition today. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court, not a warden of the state. Bail and bond for pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Mr. Jerry, your last soldier. Is it your last or
Listen and then I talk about
Dr. Amino?
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2 1.5 minutes. Your Honor, I'm ready to appear before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm appearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Smio. I think he taught me very well, and that's why I've been proceeding on. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'm not going into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification. Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a cold floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and the judge and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there's high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, are you sure you want that to go to record?
I think it should, because I can substitute
Literacy in respect to...
Your Honor, what I mean by literacy is not literally academic, schooling, but experience. And if we were to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
You're admitted yourself.
Thank you.
Thank you. Daktari, how long? I'm not
I
even sure
will
whether I will fix time for you.
Your Honor, I will be extremely brief,
Very well.
except I'm asking for one indulgence.
Yes.
one word will take maybe 1 minute or less.
Continue.
First, you look at the touch sheet. Point 1, the person's name there are 2. The particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is for government or the volume is for government. The second point related to that is particulars in the charge sheet under the law. And I take this something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication, that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was speaking this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the blood. The third count relates to the manual we're going to talk about. Last, and this is about the allegation of buying cars on the government. Something I was told when I was being taught to the young parents when I was much younger. We were told monkey see, monkey do. When the government itself lets court orders, citizens have no reason to monkey see, monkey do. When government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything helpful. So the citizens are taking after the government. And very last, I do recall off the top of my head, the governor of Istanbul, who was charged with the blood of support. The court ordered that he should not go to the county government. So this issue of interference with subordinates, if there are any, but my colleague, I just every that's not still. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are currently paid.
Thank you very much. Your Honor, I was very, the first point I would like to make to you, respectfully, Your Honor, is that several counsels or advocates have spoken. They have made submissions. I would respectfully urge that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a written ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later.
Yes.
Has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I urge you respectfully that before you rise this morning, you make an order that the governor is released forcefully certain point that the criminal law of the country must not be abused at all.
Slower, Daktari, slower.
Your Honor, I'm saying to you respectfully that you make an order before you write.
Sorry, that I scored. And it's okay.
That the governor should be released on a free bond and you will give your reasons much later. Your Honor, permit me to continue.
Go on, continue.
Your Honor, I'm a child born in the colonial days.
You're a child of
Born in the colonial days.
colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature, of sociology, anthropology, philosophy, when you had terms like the African mind, how the African thinks, and so on, from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was abused during the developmental state. It was abused considerably during more state. The only president that can put in a word in his favor is Mwai Kibaki. The criminal law was not abused during Kibaki's reign.
I think the statement is home, Daktari. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with the boldness from the petition. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Sun, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC. That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do, that it can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can someone give me the judge? Your Honor, the judge you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not being told that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Camino can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that That's on the first page. On the second page, 2,124,668. Hey, what is that? It's a full governor. 2,124,668. That's in the order. The amount involved is 2,680,461. This is of Emmanuel of Musumo. Jonah, the criminal law is being accused. During the days of let me make one point clear. A constitution has been meaningful. It must develop something called consensus. A constitution is meaningful. It must develop in some cases something called consensus. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to such. The constitution has been meaningful. It must develop something called consensus. In some cases, something called convention. You would expect that a charge against a governor of the country, the director of to satisfy himself that a case has been made out against Natembeya. Having regard to what was being told, he was arrested when. When did the DPP read the entire file? At least if I may say in favor of Charles Johnson, he would read the entire file to satisfy himself that indeed a case has been made out to millions of people. It is therefore not surprising that the people in his own area were mad to him trade at home. Your Honor, may I say draw your attention to the fact that I also have noticed entertain the council they have the government principle. That's not but a charge can be preferred against the government. The way to deal with the governor is to use impeachment proceedings that have been provided for in the Constitution. The governor. Releasing. Your Honor, one final question, one final submission, and the next to you. Please don't misunderstand me at all. What is required of a lawyer? What is required of a magistrate or a judicial officer? is to be strong and to be courageous. Might in you very respectful that rise to the occasion. The country has gone down. And we need young people like yourself, John, who have got power, to see whether we can bring up and maintain the concept. Let the executive keep its own day, not to get into other days. As currently, it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we refer to impeachment in the Nigerian presidential systems. That's why we have a lot of impeachment for governors and so on. And I've noticed that the order for this book.
What is the title?
Two are swearing that they would rather die than see Governor Natembeya in power.
Very well. Mr. Njero, I think we are done.
Yes, we are done, so it's
Yes.
Our father, the father, the profession, he has said it all. Okay, the governor, free home. At the very worst, some affordable cash flow. Let him not stay here an hour longer, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanded. Let him get his free board or cash bill, let him leave. Even a street boy here will know who is children up in there. There's nowhere where he will go. We believe. We believe. Your Honor, you do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law. You understand the law. And even as we are doing all these things, you've appreciated it. I have no doubt that today the judgment will be look out. No conditions have been sought and it shouldn't even be there. Let man go and serve. He'll have his day in court.
Thank you.
Sorry, Your Honor, do we have a right to respond?
Of course, of course. Any of these? Mr. Owiti,
Yes.
together with you on the
I'll just go alone. Most
you have
kindly.
not specified.
Yes. Your Honor, certainly the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as whether or not this court properly has jurisdiction to entertain these charges. Yeah, proceed. whether or not the Director of Public Prosecutions had power to institute these charges. Yes. And that is related to reference to Articles 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Don't talk law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges. And if your record confirms what I also heard, that there's no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3, Kibomet and another one. It's on the record, Your Honor. Oh, Mr. Sibiu, I apologize. That's why I was not sure who's in. Your Honor, although they have not given you a copy of that warrant, it says, and any other part. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to just below the areas listed. There is an any other office, business, and residential premises wherever they may be situated within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. But then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Chesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper.
The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with section 214 of the CPC. But there's a smaller issue about the amounts. This is related to the charge sheet as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. I agree with Mr. Otieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Sub-Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Sub-Article 4 of the Constitution. Before this court, Your Honor, I've never had the privilege of appearing before you. But I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. Your Honor, I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Your Honor, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But Your Honor, more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
Your Honor, is raising new facts that were not part of address to the court.
That's a question of law, Senior.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because that never arose in our submissions.
When Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP or this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify that I scored with Dr. Aminet saying something else.
Yes.
Okay.
It's going to mislead. Unfortunately, it's going to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I further withdraw.
I scored him differently,
yes.
So now that you withdraw
yes.
that point, I will not.
Most of like I've also withdrawn the arguments on 181 to I scored it differently. So I have withdrawn. Your Honor, back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there's no basis. If we can come without an affidavit, there's still basis. There's also the argument as regards saying that we have not proved, so, Your Honor.
You are now on your 12th minute.
2 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
A minute.
Thank you. Your Honor, I was referring to, please, Your Honor, just help me with your record. What did I say last? Kindly.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under 116,
that was concluded.
Then I can move to the next point. Your Honor, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor will misquoted in my presence, especially in terms of understanding. I thought it was not points of law.
You were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement in my presence. Yes. You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact. Points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. Yes, Your Honor, I'm still quoting so that I come to the point of law. Dr. Haminwa, on the other hand, says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Haron Ndubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 subclause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor. I am done. That is my last point. 4.9 subclause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Natembeya. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth, and we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
Permission to add one of the points that you made. Honorable Jeremiah Kioni, Assessor of Council, who wished to place him on record.
Now, almost one. Taking it for So I will need a break to do a ruling on the matter. I possibly need almost one. Take a lunch break. Take a lunch break. Though the issues are going into millions, I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to deliver decision, give reasons later. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by dint of their own procedures. For the subordinate courts, that actually can give ground to suspect of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged, Your Honor.
It takes courage to embrace your extraordinary. Burberry Hero, the new Parfum.